to give us her talk. Otherwise,
yeah, I think.
Yes,
Yeah.
yes, I see her. Yes. Hello, Jessica. Thank you for having joined us. And I'll introduce you briefly, and then I'll give you the floor. Jessica Oluoch is an advocate of the High Court of Kenya and a human rights lawyer at Kelin in Kenya. She's part of the Female Lawyers Network, which consists of feminist lawyers from Africa. She was also a fellow at the Southern African Litigation Center, where she was trained on litigating on health and socioeconomic rights. That's in brief about Jessica. Please, the floor is yours. I'll raise my hand when it's 18 minutes. This way you have 2 minutes to conclude, please.
Thank you so much. I doubt I'll even take that long, but I'll just proceed. So thank you for introducing me. I currently work for a human rights organization that is a group of lawyers that is committed to promoting health-related human rights. And this is what led to my conversation with Alessandra, because we have a project where we are interrogating cultural structures and the kind of cultural practices that we have and how they impact on women's property rights. So we do have a project within the Western Kenyan region that we are working with cultural structures who are specifically the Council of Elders that we have at the community level. And what we are doing with the Council of Elders is to be able to have alternative dispute resolution mechanisms, especially for widows who are victims of, will I say, gender-based violence based on culture. So the cultures that we have within this community is the practice of widow inheritance, where if one's husband dies, then the widow is, I would say, remarried in quotes, but not with consent, based on the cultures, because they say that once your husband dies, then you have to be remarried in order for you to remain in that home. And the problem is that within this area, we have a very high HIV prevalence. And therefore, this makes it a little bit problematic, because the culture as it is right now and as it is being misapplied, it has been sexualized in nature, in that for you to be remarried, there has to be a sexual, a sexual act between you and the person who's inheriting you, in quotes. So what happens is most of the widows refuse to be inherited because, again, when it comes to marriage, there has to be consent. And when one's husband dies, then it's not automatic, especially for the widow, to say that she would like to be remarried to someone else. So for the widows who refuse, they're chased away from their matrimonial home, most of them. And when they're chased away from their homes, it means their houses could be destroyed, could be locked, and therefore they do not have access to housing. And sometimes also they do not have access to the lands that they used to till in order to provide for their families. So for us, this is problematic because it goes against women's rights to property as it is, and also it goes against the inheritance rights that we have in our country, specifically specifying that, for example, when a spouse dies, then the person with the highest interest is supposed to be the surviving spouse. Over the last 10 years, we have resolved over 765 cases in total. And how we work with the elders is that they are the custodians of culture. And from their experience with us, they do explain to us that most of these practices that we have at the community level, they're as a result of the misapplication of culture. And they explain to us that actually this practice was not supposed to be sexualized, but it was meant to be protective of the widow who dies, so that there's a male figure, which is also a problem in itself, because you don't have to have a male figure in order for you to be able to own property, because also women in their own right have a right to be able to own property. So over time, we have had a partnership with the elders where we are training them on what the law says with regard to women's property rights, so that as they apply culture in resolving the disputes, then they also take into consideration what the laws of Kenya and the international human rights law specifically say about the rights of women to property. As a result of this engagement, which has been very progressive, and we have seen change in social and peer norms at the community level, and we have seen more women being able to own property, getting title deeds in their names, and even the practice slowly diminishing. But we have other aspects that we see as challenges along the way. For example, in the process of working with the elders, we realized that there's a practice among okay, there's an African practice of dowry payment, especially when it comes to marriage. So the dowry has to be paid, for example, if you're married under customary law, in order for the customary law to be recognized. But from our experience and from working with the elders and looking at the compendium of cases that we were having with the widows, we realized that most widows are saying the practice of dowry payment is contributing to gender-based violence. And our question is why? Because dowry payment is supposed to be a sign of respect to the family, and it is a token of appreciation as per our Marriage Act. So what happens is dowry payment results to women being treated as property in that sense. So when someone pays dowry, then they view it as, you are now my property. I can be able to subject you to gender-based violence. I am the one to make decisions relating to property, and therefore you're one of my properties. I can do with that as I please. And we have already done our research at the county level and interlinked that to what the human rights perspective says with regard to the right to marriage. And we are at a process of doing that at the national level so that we can be able to, for example, be able to improve development of policy in relation to customary marriages, because this means that women who are married under the customary systems then continue to face GBV because of a prerequisite that is required with regard to customary practices. Apart from that, we have also seen the widows that we work with having specific challenges, especially when it comes to our laws as they are. So in applying the law, Kenya is supposed to be able to ratify international instruments and to be able to align to that. But the Law of Succession Act as it is right now equates women to children. So for example, it says that when a husband dies, then the property that is there is supposed to be divided in units. That means that you count the wife, and if the wife has 2 children, then that unit is counted as 3, and then they divide the property equally. Not taking into consideration that when it comes to matrimonial property, there might be an aspect of contribution by the wife in the acquisition of the property. Or other aspect therein, it could even be the wife that acquired the property. And from our experience, it has always been, because we do have a lot of community dialogues within the communities that we work with. We engage them within the chiefs barazas and other widow support groups that they have. And you find that these women, as much as they engage in economic activities, when they get the monies, they give it to their husband for them to make the decisions. And when the husbands, for example, make a decision on purchasing land, they will buy land and write it solely in their name. So it won't be joint registration. It won't recognize that the woman had any sort of contribution towards the acquisition of this property. And this means this is problematic because our Matrimonial Property Act recognizes that in order for you to be able to claim a right for a matrimonial property, then you must prove contribution. And for women, the only thing they have left is the household chores, the love, taking care of children, which if you are supposed to calculate vis-a-vis somebody having the title deed with their name and other structural issues, then it becomes very hard for women to be able to prove their contributions within their family. And most of the time they lose their matrimonial property. And that was again a public interest litigation that was done in Kenya last year. And unfortunately, the decision that we got from the judge, who is not very progressive, said that if we say that property should be divided 50-50, then women will be rendered to be gold diggers in quotes. So they will skip from this marriage and get 50% of the property from this marriage, then they leave that man and go to the next marriage and get 50%, which does not make sense because nobody gets into a marriage, for example, to be able to, I don't know, to be a gold digger, number one, but it's also a very wrong perception on women to think that they will be getting into marriages just for purposes of getting a man's property. So the same is currently under appeal, and we do hope that we'll be able to get a progressive decision relating to that. And right now, we are also in the process of trying to review the Law of Succession Act because of the problematic section, the first one that I mentioned, the second one being that, for example, it encourages for customary laws to be used in specific sections. And we have known that customary law is patriarchal in nature, and in most instances when it is applied, especially in areas that we don't work with, we know very well that it will not be promotive of women's property rights, and women continue to suffer in that way. But also with regard to providing, there's what we call the degree of consanguinity when it comes to division of property upon the death of a spouse or upon the death of anyone. So the person with the highest interest is supposed to be the spouse. But then when you look at the entire degree, you realize that according to our Law of Succession Act, there's a preference for men first, and then is when they go to women. So for example, the highest person with the interest is the spouse, and then it goes to children in equal measures. But from children, for example, if God forbid I died and my spouse also died and we don't have children, then they say that the person with the highest interest is supposed to be the grandfather, and only upon his death will the grandmother have any right, which does not make sense to me, because it means the man has to have the right to this property and he has to die in order for his wife to be able to have any access to this property. So for that, we are a little bit optimistic about it because our constitution says otherwise. And we have both the Senate and the National Parliament being in the process of doing that law. And if it's not possible, then by the end of the year, we'll be able to do public interest litigation based on real cases that we have seen based on our cultural structures project. I think I will stop there so that, yes, I give more time for other discussions. Thank you so much.
Thank you very much, Jessica, for these experiences from the field. They are very much related to the previous communication of Alessandra. That's why I also understand why Alessandra wanted to speak in English, so that communication